Hello, and welcome to the webinar, Ahead of the Curve with Michele Shuster. I am Lisa Light. I am the Chief Marketing Officer here at Convoso, and I'm very excited to present this is the second installment in our quarterly compliance update, and I am joined with my friend and noted attorney, Michele Shuster of McMurray & Shuster. Michele, go ahead and say a little bit about yourself.
Well, hello, everyone. Hello, Lisa. Excited to continue to do these on a quarterly basis. I think I recognize a lot of the folks that are online, and you know me as Michele Shuster. I'm a partner at McMurray & Shuster. I'm a former consumer protection chief from the Ohio Attorney General's office and have been in this marketing and advertising space and all that entails for going on 22 years now, hard to believe. But we're excited to provide updates on what's happening on the state and federal level and to share those with you.
Fantastic. All right. Well, first of all, we want to ask a few questions of our attendees. We're really excited about our crowd today. We had over close to 150 registrants for this, so we're hoping that we'll get a lot of responses to our following poll questions. First of all, let's start our initial question, and it was just two poll questions, and then we'll get on to the content of the event. And that is, who is your current dialer provider? And for the second one, we want to know which of the following is your greatest compliance concern? Completed. Here's this other housekeeping matter. This is not legal advice, what you're about to hear. We will provide this for informational purposes. We always recommend that you consult with a counsel who has expertise in the compliance area. And if you need a recommendation for a good attorney in that area, we can definitely provide those names. A good name there. All right, let's go ahead and get started. Michele, there has been so much that's been happening recently. It's hard for those who aren't in depth into the legal profession to try and keep up. But can we just jump in? And I know on June 8th we got some updates from the major regulatory bodies. Can you bring us up to speed on those?
Sure. And you're not alone in feeling that, Lisa. And I will tell you from my many years of experience in this area and working with regulators, things are moving at a much faster pace than they ever have. And I think that's due in large part to the administrative agencies have really expanded their reach by their rulemaking processes, and also even just clarifying what they believe various provisions of the laws they enforce mean. And we're going to talk about a couple of those situations today in our updates. But as a result of that, if you don't have to go through a congressional process to amend laws, or in some cases even the rulemaking process, which can take over a year to do, you're able to affect things very quickly. And so we see that, on the FCC side, they have gone through some rulemaking that gives them the ability to start some summary processes with turning off voice service providers or carriers that they believe are facilitating illegal robocalls, as they would call them. And so as a result of these types of summary processes, things are moving much quicker.
And in terms of the alphabet soup that's out there, can you share what does FNPRM stand for?
It's a further notice of proposed rulemaking. And so it seems like every month when the FCC has their monthly meeting with the commission, we're getting new proposed rules or those further notices of proposed rulemaking or new notices of proposed rulemaking at every one of those. And that's certainly been the case since, the beginning of 2023. I think the big shot across the bow for many was the FCC's announcement that it was going to be shutting the lead generation loophole. And although that was only a few pages in a over 100-page document on further notice of proposed rulemaking, and it was kind of buried in the back, it had a significant impact on, I would assume, pretty much everybody that's on this telephone call. So, just just right now in this process, not that we've got a slide or anything for this, I'll let you know that, we are in the process where the FCC is considering all of the comments and reply comments that they have received from the industry and interested parties. And I would suspect sometime in the next couple of months, and this will be another one of those announcements that will be brought out in their monthly FCC commissions meeting, we're going to get a draft rule. And there will be another small window, but not much there. And we will find that published in the Federal Register, and we are going to have some changes. And I think that's what we can all do now. And you guys are doing it. You're attending webinars like this and educating yourself and finding out what's going on in the industry. What are the regulators focusing on? Because really the best that we can do is prepare ourselves. And, when I talk to clients about these types of things, I always talk about it in terms of defendable positions. Now's the time to figure out what's likely to happen and start building that defendable position through policies and procedures and how you're interacting with your clients that can have effect on your compliance posture. For the voice service providers out there, it's making sure you know your customers, that you have a robocall mitigation plan. For anybody that's making phone calls, you're required to have policies and procedures in place to comply with the TCPA, the TSR, and state laws. And so not having those types of things is a violation. So now is the time to start getting all of the ducks in a row so that if you, God forbid, ever do get a knock on your door from a regulator or plaintiffs, that you already have those types of things in place and you already have an answer in place. And we have found the most successful approaches to responding started with us already having the response before the regulator or a private plaintiff came.
Okay, and one, just stepping back in terms of the process. So they come out with a further notice of proposed rulemaking, and then they receive comments. And there's an opportunity to make comments either through organizations like PACE, the Professional Association for Consumer Engagement, or individual companies also can provide comments. Is there any advice for people on this call who may not be involved, how they can go about for future? Because I think that the deadline already passed for the loophole.
It did. The one we're going to talk about here is a new one that came out this month at their meeting last week, whatever that date was. I think it was the 8th or the 9th, whatever that date was, from the FCC's commission meeting. But you already mentioned the things, Lisa. You can go to the trade associations. You can team up with industry associations or even other companies if you share a common position on whatever the rulemaking is. But there's nothing that stops companies from individually filing. And if you go to the FCC's portal that accepts comments and gives you the ability to read them, you will find hundreds of comments from companies that individually file maybe a 1-page, 2-page letter that says, this is how this affects me. If you implement this rule you have proposed, this is the effect it's going to have on me, my business, and the customers that I serve. And those are very impactful. The commission does read every comment that they receive. And if you look at their subsequent rules, you will find that as a result of comments, they changed their position on some things, and they'll note it and they'll footnote it. They always have lots of footnotes in their staff reports as they're rolling out the rules. But they do listen. And I can tell you from many conversations I've had with regulators, they'll be the first to say, we don't fully understand, which is why we ask. And you have to answer industry or we won't have that information. And I can tell you always the loudest people in the room at meetings with these regulators are the consumer protection advocates. And they are not always reasonable, I can tell you, having been a consumer advocate, and I still consider myself one. But the organizations that are out there, they take a very strong, hard-nosed approach for consumers with little consideration for businesses. And that's why it's critical, like you said, Lisa, that they get involved in these types of things, educate themselves and get involved. And so the one we're looking at currently is the FCC put out a notice of proposed rulemaking that really has to do with consent requirements for calls, text, and pre-recorded messages. And this is just a very high level, what I thought were the most significant points from that notice of proposed rulemaking. And you can go to the FCC's website and you will see, if you look for the commission's meeting last week, you will see the actual proposed, the notice of proposed rulemaking that was released and their summary press releases. But what they're looking at doing is requiring that companies honor company specific or internal do not call requests within 24 hours. And those of you that have been in this business for a long time, we've always said, and the TCPA says, as does the TSR, you have a TSR, Telemarketing Sales Rule and Telephone Consumer Protection Act, that you have a reasonable amount of time to process a do not call request, and that was not to exceed 30 days. So, as a lawyer interpreting those types of things in businesses, you would say, well, then you know what, you have 30 days to process an internal do not call request. Well, they're looking at changing that to requiring that be honored within 24 hours. Also, and this is something that was touched on in the 2015 declaratory ruling that the FCC put out that basically made anything that wasn't a rotary dial phone an ATDS under the TCPA for purposes of what you needed consent to use. But they talked about in that you need to allow consumers to revoke consent through any reasonable means. And they really didn't provide a lot of clarity on that. And so what this notice of proposed rulemaking would do is to provide additional clarity on that. And so what do those reasonable means mean? Or what are those? Stop would be one for a text. And that one stop request to a text would apply to all types of telephone and texting communications to that telephone number. So that's not just a stop request for texts, it would also apply to telephone numbers as well. But it also means that if you have a public-facing email address, a called party could make a do not call request on that, and you would have to honor it. We've always wondered if you went into, for instance, a busy Home Depot on a Saturday morning and made a request to the customer service desk, would that be reasonable? I think probably not likely reasonable, but it's something that we've put out there. So, voicemail would be a reasonable way, emails, and telephone calls to publicly available information for a company. So you're going to have to be more conscious of how to accept do not call requests if that's allowed. And then also there was the soundbite decision. I think it was soundbite decision that came out a few years ago that talked about the FCC reaffirmed that you could have one-time confirmatory text if somebody sent a stop request. And including, you could send a clarifying text, is that for all campaigns or just for this campaign? Mm-hmm. And so what they're proposing in this rulemaking is that you would be allowed a one-time confirmatory text. So that wouldn't be a violation. And the reason it would have potentially been a violation is once a consumer makes a request not to be contacted, you can't contact them again. But the FCC is yet saying, yes, you can make a confirmatory text saying we've received it, and maybe even to have a clarifying question in there, but no marketing material. And that's the important part of that. You can't try to remarket them through that one-time confirmatory text. But if the consumer does not respond, the FCC clarified that that doesn't mean that you get to ask another follow-up question or that you assume that means that they wanted the more restrictive do not call request. You have to assume it is the most restrictive do not call request. And so as soon as this is published in the Federal Register, which will happen sometime in the next month, there'll be 30 days to comment on that rulemaking. And if anybody has any questions, we're always obviously happy to help with those types of things.
So, one thing that's clear is if a request to stop applies to all methods of communication, if companies are reaching out via different systems rather than omni-channel, that the systems that don't talk, systems that talk to each other will be easier to implement. But if you've got separate systems, you're going to have some sort of band-aid processes. By the way, does that apply to email as well as text and voice?
No, so it's just within the parameters of the TCPA, and the TCPA does not address emails. That's the CAN-SPAM Act, and there's a different process for that. You're required to honor opt-outs for unsolicited emails for 30 days, and there's certain ways to do that. No private right of action, important to point out with the CAN-SPAM Act. It's enforced by the FTC and state AGs.
Okay, great. All right, should we move on to the second box, FTC?
Let's do it. So FTC, Lois Greisman, who is one of the associate directors at the FTC, I have known for a very long time. We worked on the do not call laws back in the early 2000s. And so she'll come and speak to various groups, and we like to have fireside chats, and we've done that at the PACE conferences for the last two. And so we had the Washington Summit last month. And again, she brought up something that if you attend these conferences, you see has been a regular theme for the FTC, and that is they believe that for consent to make pre-recorded calls, you can only get consent from one seller to one consumer. And so she reiterated that again at the Washington Summit. And then if you pay attention to a really great document, I would say, for explaining how the telemarketing sales rule works that the FTC enforces, it's the complying with the telemarketing sales rule, and it's on the FTC's website. Really great document, goes into a lot of detail. Well, they amended that last month to say that they believe that the type of consent that you're required to have is the one consumer to one seller. And so I can also tell you that when changes like that happen, the next thing that happens is the FTC will look at the various companies that they've issued civil investigative demands to, which is like a subpoena, but on the government federal level, or for companies that have had a large amount of complaints from consumers, and they look to make a press hit so that they can make sure that everybody understands that they were serious when they said they were changing something. So, if you are using pre-recorded calls and the telemarketing sales rule applies to those campaigns, now's a good time to look to make sure that your consent is something that is valid consent for making those pre-recorded message calls.
Okay. Now, one of the things I was reading in Michele Shuster blog that it talked about these new legal requirements and enforcement actions coming from the FTC and the FCC. Are these dovetailing, or are there contradictory requirements, or do we have to go to the lowest common denominator to comply with both of them?
Yeah, so this is what I think is coming, and it's based on conversations I'm having with regulators on the state level, the federal level, but there is this implied I'm going to say that there are actions that are coming in the form of a sweep. And what the sweeps are, and they're usually led by the FTC, is they will find an area that they want to draw attention to for enforcement purposes. They'll work with the state attorneys general, and they'll coordinate the filing of lawsuits within a week or two time period, and then they'll put out a big press release about it. There was one of these that was done about 3 years ago that was around pre-recorded messages and those types of telephone calls. And the name of the sweep is escaping me now, but it was some cutesy title. But it's looking like there's going to be something like that before the end of the year again. And I think it's going to be specifically around pre-recorded messages and probably multi-seller consent forms. So something to pay attention to.
Now, we just had a question come in regarding the FTC one consumer to one seller. That is, if we partner with lead vendors, for example, Quote Wizard, then do we need to buy exclusive leads in order to comply?
So I think there's a lot of different ways that you can do this. And if you were an exclusive lead buyer and the only company mentioned on the lead form, that's the easy yes. Yes, that would do it. That's one consumer to one seller. But I think there are other ways that you can do it. You could have, multi-seller check boxes for getting consent for various ones. If a consumer expresses consent in a product, maybe there's another marketing channel that you follow up through, be it email or something of that nature, to try to get better consent. But yeah, I mean, we're talking about the most restrictive form here possible. I do believe that there are ways that you can meet this requirement that's going to keep you out of harm's way. And this is definitely an area, if you're relying on multi-seller leads or a lead generator using that method, now's a good time to talk to a compliance attorney about what's coming in the future.
Okay. And now, so about the FTC rule, the question on that is that for pre-recorded calls only, or does it also apply to live calls?
Pre-recorded calls is specifically what they were pointing out. Now, the question you have with the other question you would have with these types of lead forms is, have you gotten a proper inquiry for purpose of creating an existing business relationship would be an exemption to having to scrub against the do not call list. And so if you don't need consent for a pre-recorded call, then really what you're worried about is complying with the do not call laws. And so there was a staff opinion that came out. It was like 2006 was probably the first time the FTC was really kind of, stamping their fists on a table to say that, and in that case, it was a mortgage company or a mortgage lending company that was using these multi-seller consent forms, and they would take the consumer through various questions to qualify them, and then it would direct them to the right mortgage lenders based on how they answered those questions. And the FTC said, we don't believe this provides consent under the telemarketing sales rule. But what they also said in that staff advisory letter was, we don't believe that this would provide an inquiry EBR for the companies that are calling. And it was just left like that. It wasn't addressed really afterwards until we started hearing the FTC talk about these types of things again. But I will tell you the context this is coming up in is pre-recorded messages. So if you're asking me to place a bet here, my bet is we've got a sweep coming for pre-recorded messages for companies that are using those to make that are using those multi-seller leads to make to qualify as the consent for making those pre-recorded message calls. Did that make sense? I bobbled that, Lisa. I didn't make that very clear, but I think we get the point.
No, that is good. So let's move on to CMS. Again, that's the realm of Medicare, and we had touched upon that during our last quarterly update. So let's update us on what's happening there. What's the current state of the CMS?
Yeah. Just before leaving the FTC, this will take 1 minute. I just want to point out the FTC is on a rampage about non-compete clauses. And this has to do with you as an employer, the folks that are on this. So if you are employing individuals and you make them sign a non-compete, the FTC is saying under their consumer protection mission that that's an unfair or deceptive act or practice to use these overly cumbersome and abusive non-compete clauses. And the reason I think it's important for you to know this and to have time to act on is if I'm hiring people now and I'm looking at the contracts I'm having them sign, I'm not focusing on non-competes anymore. I'm focusing on non-disclosures and making those non-disclosure agreements very tight as to what they can do and granting yourself the ability to take some type of injunctive action to stop them from disclosing your trade secrets. Really important moving forward. We're in a competitive business and you're going to want to be able to protect yourself. So I just wanted to point that out. I think we'll see a rulemaking from the FTC here in the very near future about that. And then to CMS, I mean, God love anybody who's on the phone right now doing healthcare marketing because the rules are changing fast and furious. And CMS has really focused on the third-party marketing organizations or TPMOs. Those of you that are in that arena, you probably know about all of these. For those of you that are working with them, good to know that now for any marketing pieces that are being used for Medicare Part D or Medicare Advantage, you're required to get pre-approval from the insurance carriers prior to launching those campaigns with those marketing pieces, and you have to file them with CMS. The CMH is the Columbus Airport, so I'm traveling. That must have been on my mind, but with CMS, and so just make sure that you have those approvals and that you have your number that's provided with those approvals. Also, they're really tightening down on how you can use the CMS name or logos of the federal government that could be misleading. And so make sure you're getting those looked at and that you're being very clear about why you're mentioning those types of things in your marketing and advertising. Also, CMS is requiring that you be able to substantiate any claims you make in your marketing pieces. The types of things they mentioned were lowest premium or largest network. And you have to be able to substantiate that with current data. So data from, this open enrollment year or the previous open enrollment year, they said specifically would be sufficient for a substantiation, but that substantiation needs to be available at the time the claim's made. So just make sure you've got all those marketing pieces tightened up. also they have some really abysmal disclaimers you have to have about not providing all plans in all areas, and then providing information for CMS and also for state health insurance programs. So if you're a healthcare marketer in this area, really a lot to look at and make sure you're doing it right for open enrollment.
And are those disclaimers, are those on the web form or other web pages, or are there disclosures that need to be made verbally?
So these are on all marketing pieces, and depending upon the campaign, they could need to be made verbally as well. But what I'm talking about here is the printed marketing materials, regardless of, it's paper or email or whatever postcards that we're using.
Okay. Okay, great. Thank you. Let's move on to the next slide and talk about what's going to be happening on as of July 20th.
On July 20th, 2023, and this is something that they announced quite some time ago, the FCC is allowed to provide exemptions to the TCPA. And one of the areas that they've done that in, and is in the TCPA, is for these non-marketing calls, and specifically for these non-marketing artificial or pre-recorded message calls. And so generally we're talking about surveys. This could be calls from nonprofits or charities, political calls, appointment reminders, and other non-marketing but commercial purpose telephone calls. And that could even be like appointment reminders or updates on repair work that's going on, or those types of commercial but non-solicitous messages. And so what they provided an exemption under the TCPA, but they also recently passed rulemaking, and this was in the Trace Act, that they were required to limit the number of telephone calls you can make for these TCPA exempt calls. And so they're saying now you can make 3 calls within 30 days for those areas that have been mentioned.
And is that number 3, that's actual conducted calls, not call attempts?
That would be call attempts as well. 3 calls, period. Yeah.
Wow. Okay.
Yeah. Yeah. And then the other thing is they clarified that if you're using pre-recorded messages, you're probably familiar with having these interactive opt-out mechanisms that can be triggered either through a key press or a voice activated. And you're required to play those within 2 seconds of the completed greeting of, hi, this is Michele Shuster calling from Convoso about your voice services. And then you have to say, using this automated mechanism to make a do not call request, press 1 or say stop or say do not call or something to that effect. So that's something that is required in some pre-recorded calls anyway, and it's something that you'll be required to do for these non-commercial telephone calls now. And then again, just pointing out, you're required to have written policies and procedures on how you're honoring internal do not call requests, the disclosures you're required to make for telephone calls. The TCPA requires that you provide your address or your telephone number and every call that you complete to a cold party. Some companies, if they get hung up on and they're recording those telephone calls, they'll even have their agents still make that telephone number address recording at the end so that they can show that they're making it. And then you have to maintain those records for 5 years. So that's what will be starting on July 20th. And I don't think there's been much talk of that lately because this happened about a year ago. And the FCC had a little bit of a snafu because they were including debt collectors in there, and they had a typo in what they had released. And so they had to kind of get through those things. But we are now at that July 20th deadline almost.
Okay. Okay. Great. So we've covered several bodies, several federal regulatory bodies, FTC, FCC, TSR included that, and TCPA and CMS. Again, alphabet soup. Jorge, I see your questions. We will we'll prepare that. We'll cover that in our follow communication in terms of the alphabet soup that's out there. That's definitely a lingo hill to climb. So, but let's move on from federal to state, because there's a lot of stuff that's happening at the state level. take us through what's happening in terms of state laws and what we frequently call mini TCPA laws by state.
So much going on here. I think the AGs are feeling more emboldened than they ever have. And they are working with their state legislators to to fix what they perceive as a wrong as a result of the Facebook versus Duguid case, where the U.S. Supreme Court greatly limited what is an automatic telephone dialing system under the TCPA for purposes of what you need consent for. And those of you familiar with that decision know that what the Supreme Court said was, based on the language of the TCPA, you actually have to be using a sequential or random number generator to generate telephone numbers that would then be called automatically. And so we all know there is no system like that anymore. When telemarketing first started, I don't know, 30, 40 years ago, they had these dialers that would literally generate telephone numbers in a random or sequential manner and just hit millions of phone numbers at the same time and tie up emergency lines in police departments and hospitals and those types of things. So that's what they were aiming to fix when the TCPA was written. And the Supreme Court rightfully said that's not what the definition means. What the definition, that is what the definition means. What it doesn't mean is if you are using a predictive dialer that just automatically dials numbers that are stored. And so with the new definition of ATDS, almost nothing, and nothing that any legitimate business is using, is an ATDS. So the state said there's now this huge hole in the law, and so we have to start passing our own laws. Florida was the first. That one was greatly pulled back in May. We'll talk about that in a second. But Oklahoma, Washington, and New York now have tightened up theirs. And there's ones that are proposed in Michigan, Maryland, and Georgia, and I'm sure more to come. And what these new laws are focusing on is automated dialing. So just the automatically selecting and automatically dialing a telephone number with no definition as to what that means. But presumably what they were aiming for was to eliminate predictive dialing. And so, we now have companies that are coming back with the click to dial in response to these state laws. And so I don't know if we're going to go back to having to do click to dial, which is really ridiculous. It doesn't solve the problem, but that was the AG's response. So we see that in Oklahoma and Washington. I will tell you in the Oklahoma bill, there are so many exceptions, it likely doesn't apply. So you really need to read these carefully for what's actually being regulated. But in New York, which recently passed, as soon as you identify who you are and who you're calling on behalf of, you also have to say you have a right to be put on our do not call list or something to that effect. So you have to notify them of their right to make an internal do not call request. Seriously interrupts the flow of the call before you can even tell them what they're calling about. But every call you make that doesn't have that disclosure, that's a telemarketing call, would be a violation of New York's law. So something to be aware of. And we'll continue to update you through Convoso as states are active in this area. So always, their website's always good to go to for updates, and obviously ours as well. The last thing I just wanted to say about this is within the last month, there was a lawsuit that was filed by the state attorneys general, 48 of them to be exact, that's no small undertaking. I can tell you from having run many multi-state enforcement actions to get 48 states on board, but they all got on board for this lawsuit against Avid Telecom. And so they are a voice service provider. That's what VSP stands for. And so they allow companies to use their systems to initiate telephone calls. And the allegations in the complaint are that Avid was allowing their customers to make IRS scam calls and other calls that are outright scams without any check or without stopping them after they got notice from the industry traceback group. I think in the complaint, they said that they had gotten 350 industry traceback requests, which is a huge amount, and that they had gotten a lot of subpoenas from regulators and private plaintiffs for their information about their customers that are using their system to make telephone calls. So it's really just three huge red flags there being told that your customers are using it for scam purposes, a huge number of industry traceback requests, and then also subpoena requests. So as a result of Avid, I will tell you that most voice service providers are very nervous and are doubling down on their know your customer efforts and their robocall mitigation plans. So I already know that Convoso has a very rich process for those types of things because we have worked with them to make it so, and know that it's not Convoso being just a very difficult vendor. It is what they are required to do to make sure that you always have phone service that is not interrupted. Because the unfortunate thing is the way the state AGs and the federal agencies are working, if they believe that you are originating through your software or through your telephone lines, if you're a carrier, if they believe you're originating illegal robocalls, they are now issuing press releases and saying that we are looking at this company and they may be an unreliable provider or carrier, and they've been given 2 weeks to respond. And if they don't, then they will be deemed an unreliable carrier, and no carrier will be able to carry the traffic from that initiating carrier or the voice service provider. And so that obviously is a very serious thing, can do massive damage to a company's reputation. So I would expect that you would see really a doubling of efforts in this area from all involved.
Yeah, and that's what we always say. It's in operating companies' best interest to have their providers be really stringent on the know your customer procedures, because otherwise it can take down good compliant and compliant minded operators, as we saw with phone burner, where a couple of bad operators took a lot of people.
One to be precise, one client. Yeah. One to be precise.
Yes,
it was one, and they were very clear on that in the press releases. But there's another part to that, Lisa, and you guys should not underestimate this. There is a difference with companies that are really focusing on these types of compliance things and how the regulators interact with them when there are issues with a customer. They're much more willing to hear what's going on and to trust that the company will be responsive. And it's a different approach from regulators, because if you are a carrier, if you are a voice service provider, you will have interactions with carriers through subpoenas and those types of things. There's just no way to avoid it. No one is perfect. But having a reputable company like Convoso is an important part of that.
Okay, absolutely. And so looking at this list of customers, list of states that we see, would you expect that if, when we're talking on our quarterly update a year from now, that we're getting closer to, 50 states or halfway there, or what would you think?
Well, so the FTC has signaled that they want to start a rulemaking on privacy. And I know, though, that the FTC will not try to preempt state privacy laws. Our only hope in preempting the state privacy laws is if Congress passes a law that is a federal privacy law and it specifically preempts the states. And that is really the only chance of preempting these. And so I think the state AGs that are enforcing these and the state legislators think that the word privacy is very sexy and that it's going to get them votes in the general elections, and that we are going to see probably half of this colored with the lime green this time next year. The privacy is just such a huge issue, and as we become so connected through the internet and all the platforms, it's something that consumers are increasingly concerned about, and so it is a good political. It's a good political thing to do. And, so with the privacy laws, what you're really looking at here is obviously your privacy policy. And you can look to California, that's the most restrictive, Colorado and Virginia, and, some of those early Connecticut, some of those early ones to start with the state privacy laws really kind of gave you what we're looking at with these state privacy laws. And that's making sure the privacy policies have the required information, making sure you have disclosures on pages that collect consumer information, making sure you have good data security plans and a data security response plan, making sure that you're vendors have the required contract provisions in them to meet your requirements for the privacy laws, that consumers have the ability to not be tracked, so do not track requests, and honoring the software that allows that to happen. And then, also that consumers have right to access and delete their information or correct it. So those are generally the types of things that we're talking about with the privacy laws. Really important to get counsel that can help you meet all of the various state requirements through one program. I find a lot of the clients are defaulting to following California, which is seen as the most restrictive, but there are some other nuances in the states that you have to be attentive to. So yeah, Lisa, it's going to get a lot greener.
Okay, and it's a lot more complex to manage, calls going out to all those areas. With regard to Florida, you mentioned the amendment there. Does that, I know there were certain elements or certain requirements that Florida has that are still in place, such as the maximum call attempt.
Yes.
Can you talk a little bit about that?
Yeah, so maximum call attempts of 3 calls in 24 hours. And so that's still in place. The calling time hours also changed. And so that's, I think it's 8 a.m. to, it's 9 a.m. to 8 p.m. I should know this off the top of my head.
We've got our
than the 9 to 9. So
right. Well, we've got our updated call hours with that we have the courtesy of McMary and Shuster, which we can also call. But really the call attempts, and there's some hefty fines per calls for violating that, and it's also Oklahoma, Washington State, and the coming Maryland law also have those call attempts. And Convoso, we're always thinking about what can we do to support compliance with our customers. And one of the things that we literally just launched in the current month was a tool that we call State Tracker. And if we can go to the next slide, please. And in terms of what State Tracker does, first of all, it's the only solution. We're the only dialer that has a solution out there to manage this requirement state by state. And so it creates checks and balances. You can have automated rules to support the state by state limits. Avoid the fines and simplify it. It's a very simple user interface to support the rules that, and who knows, like you said, once that map, the US gets much more green, you're going to have, multiple rules and different rules by state. So managing that. You can also create rules based on either zip codes or area codes. And then to really support compliance in your area. So we're very excited about that. If we'd love to, first of all of our customers, we're hoping they're embracing this new functionality, and for those not using it, we'd love to share more with you. So there's on your screen, there's a chance to learn more. All right. Now, Michele, I also wanted to talk to you in terms of what the regulatory bodies that they seem to, or you've mentioned in the past, that they acknowledge when companies really go above and beyond, that you're going to have a better outcome if you have a notice from a regular body. Can you speak more about that?
Yeah, so the regulators obviously are working with a lot of the same people in this area. The universe of carriers and voice service providers has gotten much smaller in the last, especially in the last 5 to 6 years. Those that really weren't following the rules were, regulated out and sent a message loud and clear to those that couldn't do that. And so, when regulators are reaching out, and they did reach out to pretty much every voice service provider 2 or 3 years ago and asked them to respond to all of the same questions. And so, as a result of how they responded to those requests, there was a relationship that was developed with in particular the Federal Trade Commission. And so, you know, the regulators all talk, and they meet at the National Association of Attorneys General's meetings, NAG, and the FTC and the FCC go to that. They permanently have staff assigned to go to these meetings, and they talk about who they're interacting with, who they're getting information back from, how are they responding to those? Do they believe they're being complete and they're responsive? Are they being evasive and over lawyering it, is what they would call it? And as a result, you develop a reputation. And so that really goes a long way with the regulators who are now so regularly dealing in this space, as they have identified eliminating illegal robocalls as one of their #1 priorities for their term as an AG or in the FTC or the FCC.
No, that's definitely true. By the way, I want to remind people that if they have questions, please drop them into the Q&A box. And just wanted to kind of hit on that, the compliance point, because we at our company take compliance very, very seriously. As you know, our CEO sits on the board of both PACE and the Consumer Consent Council, which again helps to set standards for self-regulating our own industry. We offer, you know, there's a number of tools, and like I mentioned, State Tracker as well as others, to really support compliant outreach to prospects and customers. So we're very, very excited and proud of our reputation for managing that, and also showcasing you know, content like this. So we're very pleased to work with Michele. Michele, can you share a little more about McMurray and Shuster and how you help customers navigate through this complex jungle?
Sure. So, you know, our law firm was started by former regulators. We were 4 former consumer protection chiefs. We were on the Republican side, the Democrats came in. And so some of us had already gone to big law, and some of them were asked to seek excellence elsewhere as Republicans. And so we snatched them up and started a law firm in 2007. And Helen McMurray and I had both worked at big law firms also for a substantial period of time. And after going back to big law, after leaving the AG's office, we decided that we could do it much better. And we had a different process that we would use in working with clients. And so our law firm was really founded on core values. Being a business owner myself, I work with my clients to make sure that they have peace of mind. So I'm primarily on the compliance side. We help companies identify risk and put together compliance programs that minimizes that risk. We are very proactive in how we handle those things, not just complying with the law, but what we see as the trends that are coming, so we are prepared ahead of time. We work on putting together those policies and procedures also for registrations in the more highly regulated areas where you need to register. We work obviously a lot in the telemarketing side, and primarily me because of where I was at the AG's office when the do not call law. We spent an awful lot of time consulting with clients too on general consumer protection laws. All 50 states have consumer protection laws that regulate how you can market and advertise to consumers. So spend a lot of time on that. We've had the first fully litigated case with the CFPB, and frequently are on the other side of FTC and FCC enforcement actions, and have had huge success in that area, as well as with the state AGs. And then we also, I joke that the folks that don't come to us for compliance, we have a very active litigation group. Unfortunately, in today's world, where we have so many plaintiffs that have really turned this into a living, there are just so many cases that are filed. So we work really hard to get those taken care of in the most expedient and least expensive way with the best outcome. But we're not afraid to fully litigate a case either if we think that the position is unreasonable and the client wants to fund that. So that's who we are. We like to give our clients peace of mind.
I love the quote that's on your homepage. Peace of mind is within reach. So
yes,
definitely
that's my belief.
But your comment about, you know, professional plaintiffs, that was at least several of the people who noted the other in our initial poll about your biggest compliance concern. You know, several noted the whole category of professional plaintiffs as a key issue.
Rightfully so.
And then I wanted to also kind of cover some dates that are coming up. to interact with Convoso, and maybe you'll be at some of these events as well. We've got Contact Center Week happening next week in Vegas. We'll be having a booth there. Michelle, are you going to be at that?
I am fortunately I'm not, no.
Okay. And then throughout the summer, we've got Affiliate Summit East in New York. That's July 31st through August 1. And Contact.io, August 30th through September 1 in Denver. So we're excited about that. And also coming up later this month is June 27th. We're having a sneak peek a virtual tour of Convoso's solution, including our new state tracker tool. So those on the call, we hope you'll be able to join us for that. And thank you very much. Thank you very much, Michelle. Always a pleasure. And thank you for those who participated. And we'll see you next quarter for our compliance update.
Take care, everybody. Bye-bye.